Good evening. My name is Lindsay Sedonis, and I'm the Director of Development and Alumni Relations here at Northeastern Law. It's a pleasure to welcome all of you this evening as we kick off Reunions 2024. We have a wonderful weekend of events planned to celebrate you and all you have accomplished since you graduated from law school. And to start off the celebrations, tonight we are taking you back to the time when you were a student with our Back to Class Night event. We have three terrific faculty speakers. Some of you may have had one or two or maybe all three when you were a student. I think what's wonderful about our speakers is that they each exemplify the law school's public interest mission and their many contributions of leveraging the law across disciplines to create positive change. You'll hear tonight a bit about public health, technology, and criminal justice, and the wonderful changes in society that our faculty are making. And now to start off our program, I'm delighted to call up our moderator, Hemant Gondavara, who joined Northeastern Law in 2013 and has been a force of nature here for more than a decade. Hemant wears many hats and currently serves as Associate Dean of Academic and Faculty Affairs, Director of Clinical Programs, and Director of our Immigrant Justice Clinic. Thank you, Hemant.
Thanks, Lindsay, and thanks to Miel for putting this wonderful event on. I'm happy to be here. How many of you have taken class in this room? Just a few. Hopefully it brings back good memories. Talk about it over drinks later. My name is Hemant Gondavara. I've been at Northeastern for 10 years. It's my 11th year. Been able to do a lot of interesting things here. One of the things I love about teaching here is the kind of entrepreneurial spirit, the ability to kind of like move in different phases of your career. I've been able to, Rachel Rosenblum and I started the Immigrant Justice Clinic in 2017. That was a clinic that maybe for some of you didn't exist when you were here. And we've been able to add a lot of clinical programs. And Miel and Lindsay asked me to talk a little bit about the clinics because it is kind of at the heart of the law school. So I will just say, when I was in law school, my favorite two things in law school were being a teaching assistant and being in the criminal clinic. When you graduate and you think about what are the favorite things you did in law school, being able to combine those two by teaching and running a clinic is like, for me, it's a dream job, and a lot of the clinical professors, I think all of them, think of this job as a dream job. For some of you, you might think of like your clinical professor, I'm the director of clinical programs. I think a lot about the director of clinical programs when I started in the clinics, Jim Rowan. So a lot of you probably know Jim Rowan, who was a wonderful mentor to me and still is. So I want to talk a little bit about some of our clinics. Whenever I try to explain, I know all of you know, but whenever I explain clinics to people who are not lawyers or didn't go to law school, the first example I use is Legally Blonde. Right? Do you remember in that scene, she's in the courtroom, and she goes up and she says, "I'm allowed to argue in court." And it's because of Rule 303 of the Massachusetts Supreme Judicial Court. That's exactly what she says, right? She's across the river at another school. But that's what our students do, right? They're able to go into courtrooms, into government agencies, go into parole board hearings and argue for people in our community. We've been able to do a lot of important things. We have right now 10 clinics and practicums run by experienced lawyers. We have staff members. We also have practicing attorneys kind of outside of the law school who come in and help. Two of my former clinic students are currently running practicums. So kind of the full circle nature of the clinics is something I particularly love. In the clinics, well over 100 students per year participate, somewhere around 150. We serve somewhere around 200 to 300 clients. Sort of, if you start to kind of think of big scale events that we hold, it's closer to 500 clients per year. and we contribute somewhere in the neighborhood of 10,000 hours of pro bono legal services per year. So a lot gets done. I want to it's hard for me not to mention every single clinic. I'm going to try to give a quick shout out to every single one. But we have our community business clinic run by Darryl Walton. Just a couple of things he's done just in the last year. Ran a nonprofit legal clinic helping people in the community obtain tax-exempt status. He has focused his clinic since joining Northeastern on traditionally underserved communities, particularly in the neighborhoods right around Northeastern, in like physical walking distance to Northeastern. He's helped yoga studio, substance abuse, nonprofit, makeup artists, all kinds of different people in our community. Another clinic kind of in the similar vein is our intellectual property clinic run by Bruce Jacoby. He does trademark and copyright law. He works with people in our community. He also does a lot of work with the Root Institute of Northeastern in Portland, Maine. People he's represented just in the last year, a young mother caretaker working on educational services. Northeastern graduate students who have started small businesses, he helps them with wireless devices, software, and a very contentious topic, pickleball. Pickleball company. If you're a tennis fan, I'm sorry. I'll try to get him to work on something tennis related next year. Other clinics, the Prisoners' Rights Clinic run by Wally Hallhan and Patty Guerin, who've been there for decades. Yeah, I know. Still going strong. Last year they represented 14 people in prisons and jails in their parole hearings and secured the release of 4 different people last year. So just amazing work. They continue to go strong. I don't know how they do it. I'm already tired after 10 years. And you can always tell clinical professors love their job because they never retire. I don't know if you, at the school, I went to BU and none of the clinical professors ever retired, which is why it's hard to get a job. Our Civil Rights and Restorative Justice Clinic, run by Margaret Burnham and Rose Ziltic-Jick. They investigate cold case lynchings from the Jim Crow era. You can look up so much about them. If you go to our website, there's so much written about them and so much that they've done. We also have our Public Health Advocacy Institute that I know Dick is a big part of. Currently, especially Mark Gottlieb and Dick help that. Good round of applause. Focused particularly these days on sports gambling, which has become a real public health issue. Filing class actions. Just last year they were on 60 Minutes, so you can find that on YouTube. Couple other ones I want to get to. Our domestic violence clinic that's been around for many years, Hyatt Bira, is our clinic director there. They do 209A restraining order cases. They've focused a lot on immigration and violence, so U visas, which are for survivors of crimes, and T visas for trafficking victims, as well as VAWA applications for violence against women. We also have 2 other ones, I promise. Almost at the end. Our Immigrant Justice Clinic, which is led by Annie Georges, who's a 2018 grad who was in the clinic, and our Family Violence Immigration Practicum, who was also a clinic student, Megan Hecht. Annie works at Greater Boston Legal Services and kind of uses her caseload and brings it to Northeastern and works on cases with students. And Megan does the same with the Southeast Legal Justice Center. Just a couple of things they've done. Even as an adjunct, Annie has created a medical legal partnership with Children's Hospital, did a TPS, Temporary Protected Status clinic here in the law school where people came in from the community and students helped them file for temporary protected status, is working on Haitian asylum seeker cases, working with Afghan refugees. And then Megan, working on similar VAWA petitions and also partnering with Kids in Need of Defense, KIND, which is a local organization as well. So much of what you're hearing is sort of the work we're doing kind of locally to help, but then also, for some of our immigration things, we're actually doing a lot of remote work since COVID, since we kind of realized you can do work through screens, that we're helping people at the actual US-Mexico border who are most in need of help and don't have attorney. So there's so much going on in the clinics. You can read about it. I'm happy to send you information. I'm always happy to cheer on our clinical professors who I know work so hard and do this kind of dual thing of helping our students and helping the community. So just wanted to give a little introduction about the clinics if you don't know what's happening in the clinics these days, and I'm happy to talk with any of you after about that. I have way more to say. So that's that. So I want to start with the panel. I want to start with Daniel Medwed. Daniel's an amazing part of our faculty. I would say like one of the big cheerleaders. You know, when I first took this position as associate dean, and anytime I had a stressful meeting, I looked at my phone and Daniel sent me a text. It's like, great job, buddy. So just a wonderful person. Teaches criminal law, founding member of the board of directors of the Innocence Network. Has regularly won the Teacher of the Year award 7 times. Has been chosen by the students to give the commencement speech 7 times. James, you have a few to right? 6. I just have 1. Anyway. Also, you might hear Daniel regularly on WBUR. So, Daniel, do you like, or are you coming up? Or?
Dick's
first.
Oh, Dick's first. Okay.
Good job, buddy.
Can you text me that? Okay. Well, I'm going to do an introduction, a little introduction of everybody. So Dick, a titan of public health. I have a particular fondness for Dick because it was a night we were out at dinner, and I said, it's really a shame we don't have an immigrant justice clinic, an immigration clinic, especially with what's happening. This was the weekend after everybody went to the airports after the Muslim ban. That's for the first Friday after the inauguration. Sorry to bring up traumatic events. But Dick said, we should have one, and made some phone calls. A lot of people talked. Jeremy, the dean at the time, was a huge force in this, and this was January, by November, the clinic has already started. We started within 10 months. And we were able to do so much immigration work during that administration, and obviously since. So I have a special fondness for Dick for that reason. But a titan of public health law, fought the tobacco industry, and now works on food law and the sports gambling that I mentioned. And then, just kind of preview everybody. Hilary Robinson. Hilary teaches in tech law and how tech law influences our society. She's a key role in the Center for Law, Innovation, and Creativity, CLIC. I again ask you to kind of, at some point, check out the amazing things that CLIC is doing. And her current research focuses on the interaction between tech change and legal decision-making in construction of social order. And she'll talk about that today as well. So it's kind of a preview, everybody, but Dick.
Okay, you folks from the class of 74, I was thinking of coming here in one of my Moroccan shirts. And do I need the mic? Can you guys hear me?
Yes.
Yeah. I should use it, yes? Yeah. Okay, very good.
74, we're pretty old, you know.
Right. A frog just arrived in my throat this summer, so until then I was doing pretty good at blasting across large rooms. So I think for you folks, teaching contracts, I think I didn't make use of this. I used to sit on this chair, on this table, similar one, in a semi-lotus position, wearing my Moroccan shirt. So one of my Moroccan shirts I had changed a variety of them. So it changed a little bit since then, though I still, when I'm teaching, I'm in a room that has a podium, move it over to the corner, and I sit, I don't think I could do the half lotus again, but I haven't put it to the test.
You can do it, too.
You see, that's the kind of support that. Right. Okay. So I understand there are 20 among the 225 alums who are coming this weekend, that 25 of you are from the class of 74. So I'll go back. So I'm comfortable going back to that era. I don't often have occasions to chat with people. Oh, yeah, I remember that. So the on the I was initially teaching, I guess, contracts and administrative law. I had an upper level class in law, language, and ethics, and another one in the legal process that originally in there, but I moved on. I've been to a whole bunch of things for the last, is it 8 years? Feels like something like 8 years or so. I've been teaching civil procedure in the fall. About 2 years ago, I did double duty. I taught 2 sections of civil procedure, but one's probably enough. And I do a upper level course called Human Behavior, Legal Doctrine, and Policy Design. So I'm still doing it's the same flavor as the law, language, and ethics class I taught that some of you took. Somewhat updated about basically applying insights from modern cognitive psychology to a whole bunch of legal issues, a whole bunch of assumptions that are made by lawmakers and by judges, and indeed by other players in the legal system, prosecutors, you're trying to think about, our and the basic take on this, if you want the 1 minute version, of the class. Well, the 2 minute version of the class begins that if you believe that the best kind of public policies are those which maximize the choice of citizens, that because after all, that way everybody's utility is maximized because they do exactly what they want to do, and that's really the way public policy should be working. And that in fact was the theme in U.S. public policy from 1980. There was a fellow Ronald somebody who sort of brought it in, but the Democratic presidents also adhered to it. Bill Clinton and Barack Obama were all true believers, and that was really characterized normative American public policy since until Biden came in. If you believe that that's really the way to do public policy, then you desperately need to take the course. And the course basically, the basic insight in the course, and it comes from Daniel Kahneman and wonderful book, Thinking Fast and Slow, which the students read beginning the first week of the class, is that most of our decisions are not deliberate, reasoned decisions. The deliberate, reasoned decisions is really a very small piece of what we do, what anybody does, and it's really, and it has to be that way, because you simply don't have enough energy. The brain simply can't go around rethinking everything you do. So something, it's hard to know how to count decisions, but something like 90% or more of the kinds of choices and decisions we make during the day, we're making without consciously practicing them. That's what Kahneman calls System 1. So the System 2, the stuff but law builds, and a lot of legal doctrines and legal assumptions build on the notion that everything is really thought through. And if somebody's doing something bad, it's because, they've decided to do something bad rather than because they simply are not aware of what they're doing, not aware of, their biases and so forth. So that's a very interesting course. And I'm having a lot of fun with civil procedure. I'm teaching that when I was in law school, again, at the place across the river. Northeastern didn't exist when I was in law school, by the way. It was closed in the 50s and didn't reopen till 1968, which was the year before I came on board. At that point, when I was in law school, I knew the one thing I was never going to do was anything to do with litigation. So I didn't take evidence, and because I did take business planning. But so anyway, I've been, as you doubtless know, what happened is in the 1970s and 80s, I had to keep myself busy when I was teaching. I began teaching here. I was also getting a PhD in urban studies and planning at MIT. And so I wanted to do something with it. I know almost nothing about urban studies, but I figured on the planning piece, since I was always interested in consumer protection, I teach a course called Consumer Protection Planning. And the idea is if you're running a consumer protection agency of some kind, either a public agency or a nonprofit advocacy organization, what do you do? What do you do? As opposed to saying, I have this toolkit, I have these things I know how to do, I'm just going to apply them wherever I can find a place. The idea is to back off and say, okay, what do you want to do? What do you want to accomplish? So I'm doing that. And meanwhile, I've always not liked secondhand smoke. This came up, early on in my early years when I would go to faculty meetings, and several of my colleagues, none of whom are with us anymore, I believe. In some cases, not incidentally, but dear colleagues, really dear colleagues. But they'd be smoking in the dean's office at the faculty meeting, and I'd say, "All right, don't, please, no." And they go, sort of, "Who are you, pitcher?" I'm still trying to get over my sense that I had for so many years, something 8 or 9 years, first 8 or 9 years of teaching, that I'm the youngest person on the faculty. So, I know there was one where I had to walk out of the faculty meeting, and about 10 minutes later, somebody came out and said, "Okay, come back in." We stopped. But so I'm get to run some group called GASP, Massachusetts Group Against Smoking Pollution. So I become president of that in 1982, I think, and then or 83, and then I'm teaching the class, and I say, okay, this is real time, guys. What do I do? I'm running this, non-smokers' rights, sort of anti-smoking organization. This is a planning course. What do I do? And they're law students, so what do they say? Sue the bastards. Okay, so that was the background for, okay, I said, sure, why not? And put together the Tobacco Products Liability Project in 1984. We had our first meeting in January of 1985, international meeting with people from Canada and Israel, I think, there even at the first meeting. And that was the 25th anniversary of the first Surgeon General's report. And the project, it evolved and became part of something called the Tobacco Control Resource Center. And then that evolved into the Public Health Advocacy Institute. So, the idea of bringing lawsuits against the tobacco industry, this was, I hadn't taught torts and I hadn't taught civil procedure. So, who was I to decide that, litigation, and tort litigation was going to produce social change, or that was going to be successful, that it could even be done. But the people who had done that, who did know about it, they knew whether it could be done or not. It could not be done. It was absolutely impossible. It had been tried in the 1960s. It had petered out by the early 1970s. And if you're a legal scholar, you're very smart. And therefore, if you know something isn't working, you can come up with many, many reasons why, of course, it couldn't work. Why, of course, it's impossible. So that was the consensus of, the relevant legal scholars, which is it simply couldn't work. I sort of wasn't smart enough to understand that it couldn't work. I couldn't figure out why, if you could bring down the asbestos industry, which was what was happening at that point. And this is a product that kills more people than all other consumer products combined. Did then, still does. It's almost 500,000 Americans and something like 7 million people worldwide. I said, it got to be possible. So I pushed that, and we've had some successes there. My fantasy initially was that the industry would go belly up the way the asbestos industry did. That hasn't happened, but in terms of smoking rates, I can walk from my home in Back Bay here, and it's the rare day that I see somebody smoking a cigarette. So that was a little marijuana maybe. But it was a very different world, and those of you who are older remember it. So we've been doing that, and in the last year or two, we've taken up as a major effort going after the sports gambling, online gambling industry, sports gambling particularly, but in general online gambling. And this is a major project of ours. As mentioned, we had a story about it on 60 Minutes. We've had stories on CNN, The Globe, the Financial Times, but we're really just getting started. So we have, our first lawsuit was one against the DraftKings promotion that said that if you open one of our accounts, you'll get $1,000, and you get $1,000 to open one of our accounts. And in some sense, it's true. If you read the fine print, which of course their defense in the case is, of course, we said it all. It's right here. Like we're online scrolling through. You have to make an initial, to qualify for the $1,000, you have to make an initial deposit of $5,000 with DraftKings. Then you have to bet $25,000 over the next 60 days, I think it was. And then when that's all done, you don't get the $1,000. You get $1,000 of betting credits. So we thought this might possibly have some deceptive element to it. And we brought, Massachusetts folks know Chapter 93A case, and we're past the motion to dismiss and so forth. And we're working on that, but we're going to be bringing a lot more cases. But in addition, particularly bringing cases, encouraging others to bring cases, particularly on behalf of addicted gamblers and the families and, friends, the people who have been hurt by this, because gambling is, sports betting. First of all, sports betting has nothing to do, online sports betting has nothing to do with the kind of sports betting that was done before this. There's nothing to do with betting on a particular race at a racetrack or betting on whether the Yankees or the Red Sox are going to win the next game. It has everything to do with placing a bet on, will the next pitch be a ball or a strike? Will it be faster or slower than 90 miles an hour? Click. Okay, the next thing, click. The next thing, click. If that's not enough action, then you can bet on 6 things at once. Well, the parlay. Now, this has nothing to do with traditional gambling, where people come in with some hunch about something or other and they're willing to bet on it, or they're going to be loyal to their local teams. It has everything to do, and it was developed, basically, the principle for it, the way it works, was developed for slot machines in Vegas. And and there was a great book written about that about 10 years ago called Addiction by Design. And it was designed. It's designed to addict people. And gambling addiction, and gambling has actually been listed for the last 10 years, dozen years, I think, by the American Psychiatric Association, the World Health Organization, and so forth, as an addiction, just like nicotine and alcohol and cocaine and heroin, a similar addictive thing. The difference between gambling addiction is that half of all addicted gamblers contemplate suicide, and 20% of them attempt it. So this is really, really a serious thing. It's been treated so far as fun and games. Massachusetts Commission to Regulate It isn't even called the Gambling Commission. Anyone know what it's called? The Gaming Commission. It's just fun and games, and and we're also working very closely with Representative Tonko and Senator Blumenthal at this point on federal legislation. We've drafted federal legislation that will be, I think, reintroduced in January, and so we're making a full court press on this. And at this point, I think I'm ready to take a few questions. Unless I've answered all possible. Yes.
What relief are you seeking?
Well, the relief we're seeking in this particular case, I'm trying to recall whether, I think we're only seeking damages, but we are seeking basically $1,000, at least $1,000 per individual who signed up for this particular promotion. But again, we started with this because we looked at it and we said, this is the low-hanging fruit. If this thing ain't deceptive, what is? But it's really the building block, and we're going to be doing a lot more things in this area.
Maybe I have time for one more.
How do I keep Gronkowski out of my living room when I'm watching football? I didn't ask him in, and he's pushing dope on my 8-year-old friend. It's really, he's invading my privacy. It's not, I didn't ask him to come into my living room.
Well said. Well said. In other words, it is, to put this another way, it has transformed the nature of sports. I was never much of a sports fan, but from the people I know, pretty much everybody else, who were sports fans, this ain't, and it almost doesn't matter what the sport is, this ain't the same thing. This ain't the same football. I didn't want to see somebody promoting DraftKings or FanDuel or whatever, and I didn't want to know what the odds were. Continually be updated on what the odds were. So it has really changed the nature of sports, and for people who are sports fans, most of them are not very happy about it, right? Okay. I think, last question, yes.
Carl Mannheim, class of 74. You've analogized gambling addiction to chemical addiction.
Yes.
What about social media addiction? Does that affect the brain the same way?
Well, actually, we've done a little work. I think we've done an amicus brief in social media addiction. The evidence is less fully developed at this point, but I think there's every reason to think the answer is yes.
Next to the podium, I want to bring Professor Robinson.
I have a couple of slides. We'll do the slides version of the talk. So I've been, for about the past 8 years, 6 of which I've been here at Northeastern, working on trying to understand what it means for law and for people when you go from this computer size, a classic laptop, hard to carry around, to this computer size. We call it a phone, but really it's a pocket-sized computer. And half of my life I spent in sociology. And in sociology, we would call that a significant intervention into everyday life. So all of a sudden now I'm mobile with networked digital computing. This is a relatively new phenomenon, really just the last 15 years. This graph is showing the, on the lower curve, the shipment of PCs, laptops and desktop computers, and in the more advanced curve, the shipment of
Tell me if you want me to move forward.
yeah, or I can do it, of iOS and Android, so pocket-sized computers, if you will. We do relatively little calling on these things, even though they have the kind of legacy name of a phone, because they were initiated as networked phone calling devices. So how does that interact with the law? Well, we have this new phenomenon, often called the platform economy or platform capitalism. My work is trying to understand this from a relatively high level, trying to figure out how a new technology, specifically this pocket-sized computer, interacts with a new organizational type called a platform. So often the technology and the platform are conflated. The platforms are like Meta, which runs Facebook and Instagram, or Uber, or Lyft, or Amazon. Basically, any company that can offer you an opportunity via an app, an application, a software downloaded onto the pocket-sized computer that gives you access to a market for something. That market might be non-monetary exchange, like you're exchanging photos with a friend of yours, but it's intermediated by this platform company that's given you the kind of interface by which you see that person that you know in Auckland and you upload photos, or by which you step out on the corner and say, I want to go to the, I don't know, downtown to have a dinner, and someone you don't know, an Uber driver who also has a relationship with that app, just on the labor side, comes and picks you up. And a specific kind of legal consciousness, because we know that as we engage in market transactions in the society, that we think about them as being regulated. I can't sell my organ, and I can't sell a child I may have, but I can sell my time to Northeastern for a salary, for example. So these market exchanges are regulated, and one of the things that was kind of interesting about the platform economy when it initially started, and now it has really expanded, is that there was this kind of lack of sensitivity to regulation that was prominent like across the apps. And the earliest ones were the transportation, what we now call transportation network companies, the ones that disrupted the taxi industry, which is where I started thinking about this. So I did a field study of Uber drivers when Uber driving was illegal in Boston. I think it was the first systematic study that was done. Did it in 2016. Of course, the Uber drivers were being marketed to like it was a consumer product. So the labor product on the app was being marketed. Your app, your car is now your moneymaker. You can make $1,000 in a weekend. You can save for your next vacation. This was inviting people to enter a regulated industry that involved things like commercial insurance, giving your fingerprints to the Hackney division of the Boston or the Cambridge Police Department, having a partition in Boston between the front and the back of your car. So when I say that we're thinking here now 15 years into the platform economy about a relationship between a new technology, pocket-sized computing, a new kind of organization, a platform that says you can make your car your moneymaker, and a specific kind of legal consciousness, which is when people are offered this offer that they either think or don't think, do I need to call my insurance company because I've been like using my car to drive around my kid to soccer practice, but now I'm going to start using it to make money. So, one of the paradoxical features of the platform economy in the transportation network context is that it's extremely low paid. So these marketing techniques that were like make $1,000 in a weekend have not been borne out by actual studies looking at what people make, and that's largely because workers don't do double entry bookkeeping, so they don't think about the depreciation of the car or the things that they're putting in to do the work that they actually have to deduct from what Uber puts into their bank account. So that's kind of an interesting paradox. Another thing is that the company itself makes the app look to federal authorities like taxing authorities like it's a credit card transaction machine. So when Uber drivers get their pay at the end of the year in the form of tax, what they're getting is a third-party network card transaction statement, which just shows all of the rides, like the full cost of all of the rides that they gave. So they need to actually deduct all the expenses that they spent to be able to deliver the service at this rate in order to do the appropriate sort of measure of taxes. So what is this organizational type? Well, it's a type that is in a bargain, what we would traditionally call in contract law pairwise contracting, with the person on the other side. So this is part of the Uber agreement. It contradicts itself in two different ways. It says you have to have automobile liability insurance that satisfies passenger vehicle requirements, and you have to provide us with that insurance. And then 2 clauses later, it says you understand and acknowledge that that exact automobile insurance policy might not afford you liability for the work that you're doing here. Specifically, that if you have questions or concerns, it's your responsibility to resolve them with your insurers. So when I talk about a legal consciousness, it's inviting people into a kind of gray area, a sort of what if we were talking in a literary context, a suspension of disbelief. Like in order to really enjoy the book about the hobbits, you have to suspend your disbelief that hobbits are fake. So in order to do the work of being in the platform economy, you often have to kind of suspend your disbelief that you're engaged in an activity that is regulated by the law, which for all of us who are concerned about the rule of law, we should be interested in. So how does pairwise contracting happen? It happens through this form that we've become accustomed to, this click-through user agreement. So already here we have like a term that is novel. It's not a contract, it's a user agreement. Well, what's a user? What's an agreement? And we have become quite accustomed to just clicking through them. This, I think, was one day when I went to a conference that I had to like, yes to the Amex agreement, yes to the rental car, and say yes to the airline, and who knows what I really agreed to. So people typically don't read them. There's a function to obscuring pairwise contracting in this way. Of course, it comes on the heels of contracts of adhesion that have been characteristic of consumer contracts in the last, second half of the 20th century. But in my field study, I interviewed lots and lots of people who just said there really isn't any pair work. You just click, you agree. Excuse me, there's no paperwork. You click, you agree, you keep going. So sort of complicated, but basically what we're seeing here is a shift from a kind of linear pairwise contracting where the organization that needs something, whether it's a service or a good from a provider, makes a deal with that person and then sells on that thing to the market, to a kind of triangulated form of transacting, which is represented here, where everything loops up through this firm, through this new access to a digital technology where the worker isn't paid directly from the person who buys the ride, but is paid using that 1099 form up through the firm. All right, so as we've tried to regulate this new form of organization, this triangulated form of organization, legislatures have had a lot of difficulties. This is a part of a Massachusetts law. The top two, if you could draw a line between 127 and 69, the original version of the law was like the classic regulatory impulse. We'll have a part of this Department of Transportation that will issue driver certificates to the drivers. And where we ended up in Massachusetts, which is the bottom part, that the certificate will be issued by the transportation network company to the driver with like the threat of an audit. So we haven't really been able to intervene in the most robust or established form of this triangulated transacting in the platform economy, which is the transportation network companies, in the classic regulation way. So what does this legal consciousness look like? People have kind of learned behavior in relation to how to operate on these things. So this is a driver that said, I was in Cambridge and they used to give tickets if you didn't have a livery plate or a taxi hackney license. And I just told the officer that I wasn't doing Uber. So it's clear that the kind of platforms can delegate a specific legal consciousness to people. Here's another example. Well, I had an insurance policy. They sent me a stop and desist. They would have canceled me if I didn't stop ride sharing, but I got another insurance company and I just didn't tell them that what I was doing was ride sharing. So that's what we would call in sociology legal consciousness. It's a specific attitude towards the law that we would traditionally associate with like lawbreakers, like people who are consciously choosing to do something outside of a lawful context. Another example, you just don't say that you're using your car for commercial purposes, and at the end, this young driver says, "What is Uber? Is it legal?" You assume because everyone takes Uber, it is. So what I'd like to talk about is how this legal consciousness has kind of been exhibited in other parts of the platform economy. So we all know that Uber and Lyft disrupted the taxi business. But there were also tons and tons of scooters that were just dumped on the streets. This was Cambridge and Somerville. This is exactly this approach of a platform organization to be like, let's just see if we can get a bunch of people to adopt this legal consciousness that's like, we don't need helmets. We could just ride them on the sidewalks. They go up to 30 miles an hour, whatever. See if we can make some money. Same thing has actually, the last summer has been full of media requests that have come my way about food delivery people. So single stroke engines are pretty easy to not register. And these drivers giving everybody, really quick lunch, not so much time to get your burrito, driving the wrong way on a one-way street, driving on the sidewalk. And I think really what brought it to the attention of people is that they're single-stroke engines, so it's like that high whine, and mostly immigrant, undocumented people who were doing the work. So this has been, a big part of the recent news. New York, another example, mopeds going 30 miles an hour. A big one that has recently come to the attention of legislatures is kidfluencing. Again, here we have just a novel word for child labor. We could call it content or we could call it labor. I mean, what I'm seeing here is lighting, directing. There's probably been multiple takes. There have been some very sad stories involving tort, where, of course, what we know when people want to extract labor is that you either offer incentives or penalties. And when you have total control, as parents do over children, especially in private environments, then penalties are really, really easy to levy. So this would be an example of a legal consciousness towards torts and bodies. This is an interesting one. Anybody have any guesses why Venmo is listed? This is a dating profile on Tinder. Lisa's 19, so she's the age of majority.
Sex work.
Sex work. So we can be agnostic about sex work and sex work being work, but it's clearly illegal in most jurisdictions in the United States. So this is an offer of time, let's say, or affection or something else for payment. Venmo is a payment app. So again, there's a legal consciousness here for a young, person, of course, the profile is real, that the platform has just made really, really easy to engage in, to offer in a market, essentially, sex work. All right, so here at Northeastern, it's been really, really great to work over the last couple of years because it's easy to work with sociologists and engineers. So legal law work is engineering work. It's an attempt to figure out whether we want these things as part of our view of the good society. And if not, how do we intervene in this kind of new organizational structure to get the outcomes that we want? And I can't say enough good things about how easy it has been to work with engineers to think all right, so if we're talking about the kidfluencing context, then do we need to actually set some legislative ceilings that say if you have 30,000 followers and 80% of your content involves a minor, then we're actually sending something like OSHA into your home environment to figure out what's going on there, proactively regulating it. So we have to think about these things in an engineering context, and my last couple of slides are really just about the expansion of this. This is when I started, a year after I started here, and then, so there's, a lot going on. This is about the wireless spectrum. This is about AI, a Center for Trusted Parent AI. This is a huge group of philosophers. I'm there on the left. I think I am the only lawyer in this group, but philosophers, engineers, people who are really starting to think about the law in relation to other forms of engineering. And I think Northeastern is just uniquely not siloed in this regard, maybe because it's grown so much as an institution and into a research institution over the last 10 or 15 years. So yeah, I'm happy to answer any questions.
maybe one or two questions?
The same question for Dick Daynard. What about social media addiction? Can you translate that into the tech platform?
Yeah, totally.
The question?
The social media addiction, how do you sort of translate, I imagine you're asking, since social media is a social problem, addiction is what we would call in sociology a social problem, how do we deal with that using the law? So I think of the addictive features of platforms, the little red bubble that's like on countless of your apps right now, like come here and look at me and do something. That is I think of it as a labor extractive feature. These platforms are thin organizations in that they can't justify their value based on any corporate asset. Their value is based in the number of users and the amount of their activity. And for me, that's time and motion, which is a really classic measure of labor. So I am currently working on a piece that is thinking across platforms about them as labor extractive organizations. So for example, if we're talking about addiction, if the platform imposes some kind of bottleneck, where in order to get from this point to that point, you have to do something, we could say that you can only put X number of bottlenecks a day in a particular application. The first one was CAPTCHA, by the way. So proving that you are a human while also identifying traffic lights is labor extractive. And we just, again, all of this kind of activity has made very powerful players in the economy. And when you ask just this basic question, where is the missing mass? It's like a physics question. We know all these planets are in the universe, but we can't explain the way things move without black matter. It's our labor that is the black matter in the platform economy. And I think we can figure out ways to make it more visible to ourselves and to compensate it. And particularly when it involves children, we can jump in and do a lot better. And I think it's just early. It's like early industrial capitalism. There were big machines then. There's small machines now. But capitalism, quite naturally, increases production by any means that it can, using nature and human bodies and activities. And I think we're just trying to figure out in this new moment in capitalism, how do we set limits on the utilization of those resources?
Last but not least, Daniel, to do the commencement speech.
Okay, I have to correct the record on that. I have not been the faculty commencement speaker here 7 times. James's record is intact. Only a few times here I've been at other schools. Okay, and the only reason James isn't augmenting his record right now is because he has chosen to be our boss. Okay, so he's out of the classroom, so it's not in jeopardy. You guys are a hard act to follow. We got the big brain over here who's talking about things I barely understand. And I learned so much from Hilary every time I read her work. I've had the benefit of being one of her mentors, official and unofficial. So I get to read her drafts, and it's really been an incredible learning experience. I don't use Venmo anymore for anything I offer. That's part of it. And Dick, I've learned so much from Dick, right? How to be a citizen, how to be a teacher, where are the best smoke shops in Boston? He's the perfect source for every vice, and advice and vice. Right? That's Dick. So as Hemant kindly mentioned, I do criminal law. I'm a former public defender in New York. Any New Yorkers in the house? All right, that turned not too far. They're not going to win, right? It's the World Series. You don't want to watch them because you have to watch all these ads with Gronkowski and stuff. So forget about the World Series. So I'm a former public defender. I did appeals and post-conviction work, then ran a small innocence project at Brooklyn Law School for a few years before becoming an academic. And I always wanted to work at Northeastern for a number of reasons. The big reason, of course, was this idea of working closely with students and the experiential education model in which students work with teachers and work with lawyers and the community to really advance our social justice mission, which is always near and dear to my heart. So I've been able to do a million different things here. In terms of research, I've been able to do traditional legal research, law review articles. I've been able to do a lot of eds, I've done a lot of media, I've done a trade book that didn't sell very well. I've gotten to do everything because the culture really allows us to do whatever we want. But the thing that gives me the greatest joy, and probably for many of you is your greatest experience, is working with students on real projects. So in my few minutes, I'll just give you a taste of a couple things I'm working on with students right now. So I'm working on a case from Nebraska. Any Nebraskans? No Nebraskans? I know there are Alaskans here, right? This is Newsel. No Nebraskans. Well, my wife's from Nebraska, which means that I'm really interested in working on cases in Nebraska. So when I go home for the holidays, I can get away from my in-laws. But I can't be like, I'm getting away from my in-laws. I'm like, there's an innocent person in prison, Charlene. I have to skip Christmas dinner. So I'm working on a case from North Omaha right now, which is a majority minority community. It's the birthplace of Malcolm X. And here's the case. I'm working on it right now with a student named Eiley. She worked on it with me all last year. She just graduated. And she's a public defender in King County, Washington, where she's from. She's a Seattle public defender. She just passed the bar. She is awesome. And she's the classic Newsel student. Came here because of experiential education. Anybody from Seattle? All right, we got to see it, right? So Eiley and I, here's the case. Back in 2000, there was a fight between two men outside a hotel over a car. And one of them got shot. My client supposedly was the man who handed the gun to the man who shot the other guy. Okay? So my guy was an accomplice to the principal's murder. The way the case went to trial, the principal and the accomplice were supposedly tried jointly, but they managed to sever the trial. And usually the way that works is the principal goes to trial first, and then the accomplice goes. But for a variety of reasons, the accomplice, my client Ernest, went to trial first, and he was convicted of being an accomplice to first-degree murder. In Nebraska, life. Okay? Then the principal goes to trial after my guy, and he's acquitted on self-defense grounds. So my guy's in prison for a crime that was legally justified. Oh, and by the way, my guy Ernest is innocent. He didn't do it. He was there, but he didn't hand over the gun. The only person who implicated him was this guy who was in the wind, this guy Alexis, who's just in the wind and was known to be a recidivist snitch and informant who often would get favorable treatment from the authorities in exchange for his testimony. So Eiley and I got this case, and we're working with a couple of Nebraskans. I had to get a big team to get out of the house, right? So we went down to the prison. The state prison's in Lincoln. We met Ernest, who's a very earnest man, and a wonder. I've done this work for a long time. I don't put a lot of stock into the interpersonal relationship because I know how easily I can be deceived. And I also know how easily, how ill-equipped we all are to evaluate honesty and to separate deception from truth. So I'm not in that business. But I do have a sort of, can I say bullshit barometer? I think I can. Yeah, this is Northeastern. I have that meter, and it's fairly well-tuned at this point, at this stage. So we met him, and then Eiley worked for a year to find this guy, Alexis Fulton. And we're in the process of figuring out the best way to approach him. So maybe sign an affidavit admitting that he had lied, because we have reason to think he may be willing to do it. This is Ernest's last best chance. The Nebraska Supreme Court has turned him down many times. Here's their reasoning. Because under the law, some of you might think, well, it's a little strange. A guy gets convicted of being an accomplice to a crime that is not a crime because the principle was justified. It was self-defense. Like it's what's called a repugnant verdict if it were in a single proceeding. But the way the Nebraska Supreme Court has parsed this is they've said, we don't know exactly why the jury acquitted the principal. It may have been self-defense, or maybe they just thought he was innocent. So it's not necessarily a contradictory ruling. Even though the whole defense theory for the principal was self-defense, the Nebraska Supreme Court has said, well, we don't know what the jurors were thinking, right? So we really need this guy Fulton, and Eiley, even though she's in Washington, she's still on it. Second thing I'll mention, I'm working on a case with two other classic Northeastern students right now. We've got any Vermonters in the house? All right, we got Nick from Vermont. Nick is Newsel, okay? Nick, after high school, he didn't want to go to college. He did every job in the book in New England. He was a longshoreman. He was a waiter. He drove cabs. Super smart kid. Worked his way through college as part of the Vermont state school system. It wasn't at UVM. It was another school. And he came here, and he's a superstar. He's one of our best students. And the other student on the team is a wonderful student named Megan. So Nick's a third year. The other student is Megan. So get this. A couple years ago, under James's leadership, we started a new program called the Flex JD program, where we have students who are basically come here sometimes, but actually do much of their work online because they live in remote locales. And we're it is again, sort of the most useful of things to do, because we're trying to create a program that will appeal to people who maybe have full-time jobs and for financial reasons or life reasons or family reasons can't be in a residential 3-year law school program, right? So Megan is one of my students I met through FlexJD, and it's typically a 4-year program. Megan lives in Honolulu, so I'm really jealous. I met her while I was teaching criminal law to that group in the winter. So I'm in Boston online, and Megan has like a sunset through her window, you know? But she aced the class, so now she's doing a lot of work with me. And she's a harpist on the side. She's in the Honolulu Symphony, okay? So she's like, I mean, this is Newsel, right? You got Eiley from Seattle kicking butt as a public defender in her hometown. You got Nick, longshoreman / he's going to be a prosecutor here in Middlesex. He has his job lined up, and he's going to be a progressive prosecutor. And he's going to do the right thing. He believes very much in decarceration, and he's going to try to make that happen. I think he will be the DA for Middlesex County, which is where I reside, in about 12 years. I can't get his last name at this point, but vote for him in 12 years. And so here's the project that I'm working on with Nick and Megan. The Nashville Public Defender's Office has hired me as an expert witness on prosecutorial misconduct. Here's what happened. It's a death penalty case out of Nashville. A man was convicted of murdering his wife. And the only real witness against him was their shared mom, who was pretty young at the time, but not like, she was like 11, okay? And over the course of the proceedings, the prosecutor became so enamored of this young girl that she adopted her. What? So the prosecutor, and by the way, there's some evidence that maybe the young girl is an alternative perpetrator. She was very angry at her mother as well. So it's not crystal clear who in fact killed the mother, okay? So basically the lead prosecutor in a capital case in Nashville, Tennessee, adopted the main witness in the case. And my charge with Nick and Megan's help is to write a report about why this is unethical. This is a fun one, and we're getting paid for it. So they're doing the first crack. We're reviewing all of the material at the moment, and I'm really looking forward to working with both of them. So it's really just a delight to be here, mainly because of the students, right, and the culture of collaboration that is very much part of the DNA of this institution, from Dick's generation through Hilary's generation, and under the leadership of him and James. So I just have a couple minutes left if you guys have any questions. I mean, I'm between you and the bar. It's a real problem. Hi. Yeah.
I just have a question with regards to at what stage of the criminal proceeding was the young lady adopted?
Oh, that's a great question. It was in the post-conviction stage, the adoption, but the relationship, there were all these moments of like going to the lake together. And it was sort of a long, I think it comes, and I haven't gone through it enough to give like a nuanced interpretation, but I think it came from the prosecutor apparently is quite religious. And there was this idea of like a salvation motive to this. And so it maybe came from a place that a lot of us might find, somewhat noble, right? She wanted to care for this young girl. But it's a conflict. and so I think, I think the initial engagement was pretty early on.
To have you disbarred?
I've tried that before. It's pretty hard, but I'm at this stage, I'm not sure, but what we're looking for is a new trial. Because or at minimum, we're hoping to get a commutation. Because he's on death row. So it's a capital case. So the main concern for those of you who do capital work, and I do a little bit of it, is just to spare the life, right? So I think my goal is just to write a report Again, I'll have to call it as I see it. And I mean, I see it a particular way right now. I don't know exactly what it's going to look like when we do all the work. But the idea is that maybe it would help with a commutation. It's either a new trial or it could convince the governor. Governor of Tennessee is actually fairly good on some of these clemency issues. Some of you may have heard about this case involving Centoya Brown, who was a sex worker in Nashville who had her sentence commuted. She had killed a patron who she thought was reaching for a knife. It got a lot of news. Rihanna was one of her backers, the great singer. I love Rihanna. She's awesome. And she gets a lot of credit. I mean, yeah, well, come to Newsville, you can work with Rihanna. Thanks.
I just noticed there's a full moon. All right, so this is the end of the program. I just wanted just a couple of quick thanks to the Dean, James Hackney, for his support for this weekend, specifically, but for the alumni in general. And then for our three wonderful panelists who did such a great job, I learned something. And then Lindsay, Miel, and Julianne, thank you for putting this event on. It's awesome. Thank you.